So this is a brief presentation as part of our law and policy series where I'm going to talk about how startups are using patents to protect quantum computing inventions. And just for those of you who haven't met before, my name is Thomas Plunkett, or Tom, and here's my email address, my first initial, last name, at harrisburgu.edu. So just a brief disclaimer. Yes, I am a patent attorney in the U.S., and today's presentation is a general presentation on U.S. law. I'm not going to be talking about legal doctrines for other countries. They have similarities, but there's a lot of differences. Furthermore, this is a general presentation. It's not legal advice. Legal advice requires a relationship between the attorney and the client and so forth. And its legal advice is based on specific facts that the client is facing. Okay, so we get all the disclaimer stuff out of the way. All right, so just a little bit about me. Along with Terrell, I'm one of the founders of the Harrisburg, Philadelphia Quantum Meetup. So I'd like to thank all of you for attending tonight's presentation, as well as some of the past presentations we've offered. Terrell has done an absolutely fantastic job as a co-founder. You know, I've been doing meetups and user groups for over 20 years, and Terrell's the best co-founder I've ever had. So my hat's off to Terrell for all his hard work. Along with Terrell, I teach quantum computing for Harrisburg University. Have a lot of fun doing that. In fact, I see at least one of my students is in tonight's meetup, so welcome. Previously, I practiced patent law in San Francisco, representing startups and large companies. And so a lot of what I'm going to be talking about tonight is obviously based on what I experienced as a patent attorney practicing law. Now, patent attorneys will have technical degrees in addition to law degrees. And one of the reasons for that we'll be talking about later on is you're dealing with highly technical areas, and having a general lawyer working in one of those highly technical areas would have drawbacks, significant drawbacks. My background was originally computer science based, and then I dived into blockchain and cryptography and computer security. And because of the potential impact that quantum computing is going to have on cryptography and computer security, that's how I migrated into quantum computing. And since then, I've actually been spending some time touching up my exposure to physics and learning more about quantum mechanics and quantum physics. All right, so that's a little bit about me. Let's dive into the topic for tonight's presentation. So I looked at this agenda from the perspective of what would a quantum entrepreneur want to know? If you're thinking about starting a startup in the quantum computing space, and you want to know, what do you think you need to know about IP law? Or maybe you're already in a quantum computing startup and you're beginning to encounter issues that are related to IP law. What would you like to know? So that's the approach I took in putting together tonight's agenda. So the three main topics I want to talk about, I'll give a high-level introduction to intellectual property law, again, based on U.S. law. Then I'll do an introduction, a much more detailed introduction talking about patent law, because patents are something that are going to come up in quantum computing space in a lot of different ways. And then we're going to take a look at a couple quantum computing patents. So that's what my focus is for tonight. Now, we have two additional speakers we've announced in this Quantum Law and Policy series. Anthony Tripp is going to be speaking on July 13th, and he is going to do what I'll call a patent landscape presentation. I mean, the title of his presentation is Patent in the Quantum Information Technology Realm, Things to Keep an Eye on, but he's going to do what I'll call a broad brush, because he did a research project where he looked at over 300 different patents that had been filed and obtained through the U.S. Patent and Trademark Office with regards to quantum technology. And so he's going to talk about the types of things that IBM, D-Wave, and other companies are pursuing in the patent space. And so he'll give sort of the broad picture. I'm going to give sort of the how and what are patents picture. So I'll explain what patents are, and I'll kind of walk you through how they work. And then he's going to give kind of the broad markets view of what are all these companies competing on when they pursue patents in the before the patent office. Then on July 14th, Paul Steimers is going to give a presentation on current issues in U.S. quantum policy. So his is going to look from a legislative perspective. He's a lobbyist in Capitol Hill. He'll be talking about what is the U.S. Congress doing, what are the trade associations doing to promote quantum policy through the government. So that's a brief look at tonight's agenda, as well as the two presentations that are coming up later in July. We're also pursuing additional speakers. So if anybody who's on the call tonight wants to volunteer to give a presentation, please get in touch with Carol or myself, and we will add you to the schedule. Also, even if you don't want to give a presentation, but you would recommend someone else to give a presentation on a particular topic, again, please let us know who you would recommend. So before I dive into the details of tonight's presentation, are there any questions? The floor is open. Please ask your questions or offer comments.
They're not stirred up enough yet, Tom.
All right. Well, I'll continue on then. So let's start off with an easy one, which is why do startups and other companies protect intellectual property? Well, there's four main reasons that I would say startups and other companies protect intellectual property. The first reason is that intellectual property can be used to increase your market share by excluding a competitor. If you exclude a competitor, then that reduces the supply of products, and therefore the price goes up, assuming demand stays the same. And so patents can be used that way, copyright can be used that way, trademarks can be used that way. All the different types of intellectual property rights that we'll talk about tonight can be used to increase your market share and increase your sales. That's the number one reason why intellectual property rights were originally created, to increase the amount of money that an entrepreneur can make. The second reason is a more defensive reason that has come up, but has actually turned out to be, as in my experience, the number one reason why startups and other companies invest in IP protection. And that is the idea of cross-licensing. If an existing competitor has intellectual property rights and you don't, you may get a very large bill in the mail from that competitor saying, pay me $1 billion or get out of business. And the way to defend that against that sort of demand letter is to respond to his demand letter by saying, you know what, I happen to have intellectual property rights too. And if I go out of business, so do you, because you are violating my IP rights. So the number one reason why startups and other companies invest in IP rights is to defend themselves from others. And this is why I put it as cross-licensing. There are two other reasons why I see startups and other companies investing in IP rights. Mergers and acquisitions. Intellectual property rights can significantly increase the desire for a potential acquirer to buy your company if they can't recreate your product and copy it because you protected it by IP. And that also gives a big incentive for venture capitalists to want to see that a startup has IP rights, because a venture capitalist knows one of their potential exit strategies is a merger and acquisition. And so VCs tend to really like seeing that a startup has some IP rights to protect their investment. The final reason why startups protect intellectual property rights has to do with licensing transactions. You can actually license or sell your patents and other IP even if you haven't created a product. And in fact, there are now, third parties who will buy up patents from other companies, even if they don't care about the product. And sometimes you'll see mergers and acquisitions that are entirely driven because of the IP rights and have nothing to do with the underlying products that the company had created. So those are all important business reasons why startups see a lot of value in intellectual property. So let's talk a little more in detail, though, about what are the different types of intellectual property rights that startups and other companies are interested in. So there's four categories of intellectual property laws, and these are the four broad categories: patents, trademarks, copyright, and trade secrets. Trade secrets is the one that I think most people are most familiar with. You know, it's the secret formula for Coca-Cola. It's keeping software source code secret. It's basically keeping something secret. You know, if you sign a non-disclosure agreement, it's usually around trade secrets. So the trade secrets is pretty straightforward. It's a pretty easy doctrine of law. You keep it secret, and therefore, if you know, you can protect the information. The other three are slightly more complicated, and that's copyright, trademarks, and patents. So for copyright, we're really talking about content. You know, the newspaper, written content such as books, the actual source code, you know, written out for software programs, video content such as movies, audio content versus music, you know, Mickey Mouse, you name it. And in fact, so in the case of Mickey Mouse, obviously, you know, it protects the character of Mickey Mouse, so someone else can't use him in the story. Only Walt Disney World can use him in the story. Trademarks are really the brand or the name of a company or the logo of a company. You know, Apple Computer, Apple Records, and so on. Patents are all about the invention or discovery of something new. You know, the invention of Morse code, the light bulb, the iPhone, software applications, computer hardware, anything that's new or non-obvious can be covered by a patent because you're claiming the invention of that thing. Now, the way these intellectual property rights work is they all work slightly differently. And so they all have their own supporting legal doctrines. And so we're going to spend most of our time talking about the legal doctrines for patents. But in some cases, you could use multiple of these IP laws to defend the same product. So let's take it for example. Let's say you are creating a quantum computing software company. You know, you're going to be building a software platform that runs on top of the hardware platforms. So, you know, your inventions could be covered by patents. The name of your company, your brand of your company, that can be covered by trademarks. The quantum computing software you create, that can be covered by copyright. And then the source code, if you keep it, you know, confidential, you keep it as proprietary software source code instead of open source, then that would also be covered by trade secrets. So all four of these legal doctrines might be applicable for a particular company. So let's dive into each one of these doctrines in a little more detail than we have so far, and then we'll spend a lot of time on patents. But I want to show these other three doctrines just to give you a little more feel for it. I'm not going to go any further into trade secrets, but I'm going to go a little bit more detail into copyright and trademarks. So my favorite trademark case is the Beatles versus Steve Jobs. You know, in the 1960s, the Beatles were world famous. And they set up several companies to handle their music. And one of their companies was called Apple Corps, which is like a parent company. And then Apple Records was the specific company that handled their music records. And, you know, they spent a couple $1,000s on, you know, setting up trademarks for Apple Corps and Apple Records. Well, in 1976, Steve Jobs files the Apple Computer trademark for his new Apple Computer company. And Apple Corps said, hey, you know, this sounds a lot like Apple Corps. And they sued Apple Computer, and Apple Computer had to pay the Beatles $80,000 in 1978 and agree not to enter the music business. Well, computers evolved, and you know, people started playing games on computers. They wanted to have music to go with those games, and so Apple Computer got sued again another 10 years later. And they had to agree to end all music and multimedia efforts for their computer line, including the Amiga and the Macintosh. A couple years later, they got sued yet a third time by Apple Corps. And they had to pay $26 million to Apple Records because of the chimes capability they put in their computers. And 10 years later, Apple comes out with the iPod and the iTunes. And so in 2000, so that really drew on. And so for 4 years, while iPod and iTunes were out, the Beatles were not on it because Apple Computer was being sued again by the Beatles. Finally, in 2007, Apple Computer paid $500 million to purchase the trademarks from the Beatles. You know, you think about all the money the Beatles made on music. They made $500 million off of a few $1,000s they spent on trademarks in the 60s. That's a pretty good investment. So, and that just gives you an idea of, you know, a small investment in intellectual property can eventually have a large payoff. Now, obviously, not everyone's going to have a large payoff like that, but it's an interesting case on how valuable IP can get. So trademarks are all about protecting brands. So when you are selecting a brand name for a new product, you really want to think about how that brand name is going to play under trademark law. So that's when you would talk to an IP attorney. And one of the things you want to do is you want to avoid brand names that are generic. So if you're planning to create a qubit processor, use something else other than qubit processor as your name. You know, if you think about search engines, you know, Yahoo, Google, those were names that, you know, they came up with because they didn't want to just call it, you know, the search engine. They wanted a stronger brand with a separate name. You want to register trademarks in jurisdictions where your organization plans to compete. Trademark registration is a examination process where you actually fill out an application, or your attorney fills it out on your behalf and sends it off to the government, the U.S. Patent and Trademark Office, and then they examine it. They look to see if there are any other trademarks that are similar. They may make some adjustments to it, and a back and forth between the government and your trademark attorney can take over a year. But basically, it's a pretty straightforward process. And then once it's awarded, then there's a certain amount of time that you can keep it, which is basically, so long as you keep on paying maintenance payments, is basically forever. All right, so that's trademarks. Copyrights are even easier. You don't even have to register them. You can just put the copyright notice on a document and it's copyrighted. If you think that you may go into litigation over your copyright, at that point, it becomes relevant to consider registering your copyright. If you think there's a potential for litigation, then you might want to register. If you're considering registering copyright, I would talk to an attorney to see what the attorney thinks is whether or not it's necessary or not. One other common area of copyright that comes up quite a bit in the high-tech area is open source software. Even though, you know, you can see the source code for open source software, it's still under a copyright. So if you're using open source, you should really have an attorney analyze how the open source software license impacts the products you build as an entrepreneur that build upon OSS software. All right, so that's really all I want to get into in terms of copyrights, trademarks, and trade secrets. Before we go on to patents, are there any questions about copyright, trademark, and trade secrets?
Tom?
Yeah,
what's the cost for such things, ballpark-ish?
Okay.
$10, $100, $1,000, $10,000?
Yeah, so trade secret is free. You just have to keep it secret. Now, you might have some compliance processes to ensure that unauthorized people don't see the secret formula for Coca-Cola or don't see the secret source code. But so there might be a cost to those compliance processes, but it doesn't cost you anything in terms of legal fees or government fees. Copyright's the same way. If you actually register it, there's a minimal fee, but it's almost zero. So copyright, again, there might be some compliance things, but there's no real major source of fees for copyright. Now, if you sue someone, then you're talking litigation costs can be quite high. So let's put litigation costs to the side. Trademarks, of those three, the trademarks are relatively cheap compared to patents, but they're still getting into significant costs. You're probably talking about $1,000 to register a U.S. trademark. But that's in comparison to when we talk about patents, you're probably talking about the equivalent of buying a car.
Question?
Yes.
So let's say we are writing software and we want to use some third-party open source with MIT license or Apache 2.0. Are you saying we still need to seek advice?
So generally speaking, So if you have an attorney who's an IP attorney, I would just clear it with them. The Apache license is really easy to work with. It gets much more complicated if you use like a GNU GPL license, but Apache's pretty easy to work with. They usually mostly are requiring, that you don't, they're mostly requiring stuff that most people will do. GPL tends to be a much more restrictive license. But it is a good plan to, have a discussion with an IP attorney as to what your strategy is as far as when you're working with open source software underneath your product, yes. Doesn't have to be a long discussion, but it's a good idea to at least have a discussion. This comes in particular if you're interested in doing a merger and acquisition, because typically what they'll do is, as part of a merger and acquisition, they will require a due diligence, and at that point, they're going to want to know what processes and controls you had in place for using open source software. And if you don't have any processes or controls in place, that may delay the deal. So that's why it's good to at least have a discussion ahead of time on that topic.
All right, thank you.
Any other questions? Okay, so let's talk about patents. This is one of my favorite quotes of patents, and it's from Abraham Lincoln. He talked about the fact that before the patent system, any man might instantly use what another person had invented, so that the inventor had no special advantage from the invention. So the patent system changes that, giving the inventor a limited time exclusive use of the invention, and thereby adding the fuel of interest to the fire of genius in the discovery and production of new and useful things. And in fact, Lincoln was himself an inventor. He created a invention that helped riverboats get over logs that are in the river. And so that's a little picture of his invention that's actually in the Smithsonian. So what do patents do? Basically, the idea is you get an invention and you have the exclusive right to use that invention for a limited time. Usually around 20 years with some minor adjustments. And in fact, if you think about a company, almost all of them are pursuing patents these days. Steve Jobs in 2007, when he announced the iPhone, held it up and said, boy, have we patented it. Him and his team had filed over 200 patents on the iPhone. Different aspects of the iPhone, from where the buttons were placed, how it slid, how everything worked on it. He himself was a named inventor on more than 300 patents. So let's talk a little bit about how you obtain a patent as an entrepreneur. So patent applications are examined by the U.S. Patent and Trademark Office, similar to the trademark applications. However, it's a much more complicated process to obtain a patent than it is to obtain a trademark. Terrell had asked about the costs associated with it. Obtaining a trademark probably costs somewhere in the nature of $1,000. Obtaining a patent could be, $20,000, $30,000, $50,000 in between the fees the patent office charges and the fees an attorney charges. Inventors who want to obtain a patent should expect the patent application process to take between 3 to 5 years from the date, the patent application is filed until the patent issues. And then it's, it's a patent in force for up to around 20 years after that point. Now, those are rough ballparks of figures. Some patents go through the process much faster than 3 years. Some take much longer than 5 years. But, you should expect as a general ballpark 3 to 5 years to obtain one. Competing patents are evaluated on a first to file basis, with the earlier filing date winning. So if you do have an invention and you think you want to obtain patent protection on it, you want to do it as soon as possible, because the earlier the file date, the better. Also, the way the patent office determines whether or not a patent should be awarded is it compares the patent to whatever documents already exist. previous publications, prior art. So if there are publications that describe the same thing, then the patent won't be rewarded because they'll claim that someone else made the discovery first. So file your patents early so that other publications won't come along and prevent your patent claims from becoming valid. So that's the basic process of obtaining a patent.
I have a question.
Yep, go ahead.
What if you are, do they look to see if you've been patent somewhere in another country? Can you patent now in the US? Is there?
So there's a process for that. So let's say so typically what would happen is there's an international process of patent cooperation treaty. And so there's a whole process where, say for instance, you filed a patent in China, you could then bring it to the US, or if you filed a patent here in the US, we can then bring it to China or Japan or any of the other countries. So there is a process to do that. And typically what will happen is, the patent attorney who files the patent for you in whatever the first jurisdiction is will work with patent attorneys in that other country or those other countries, if you're going after several countries, to file the patents over there. But yeah, there's a formal process for doing that. Any questions related to that? Okay. So
I'm sorry.
Yeah, go ahead.
Sorry, just a little late. So let's say we filed for a patent and only 1 year passed. What about using this invention by other companies?
All right.
That first initiative.
So let's suppose that you filed for a patent, okay? And let's say, a year passes. So at this point, and let's say you have other companies, okay? So these other companies couldn't then file for the same patent. But, let's say you own multiple companies, you own companies A, B, and C, and company A filed for the patent. So company A could just give company B and C the right to use the patent if they wanted to. And in fact, we'll talk about that. I talked about that a little bit when I mentioned licensing earlier. So basically, when you have an IP right, like a patent in this case, you have a right to exclude others. You can pick who you want to exclude. So if you own several companies, A, B, and C, company A could allow companies B and C to go ahead and use the patent, but then other companies who are competitors, company A could exclude them.
Hey, Tom.
Yeah. Hey, Tony.
Hello. Just one other small thing to point out, because I'm not sure I heard you mention this yet. And not to get too far into the weeds, because I know that's not the point. In the U.S., we have something that's called a provisional application. And stop me if you're going to get to that on another slide.
I will, but go ahead.
Yeah, and so when people throw around this 1 year actually means two separate things. You have a year from the time you file a provisional, which is the idea that you think you want to file a full application at some point. And then the actual application itself, the real application, you have a year through which the provisional is still good and you can file this application. And you can either file for it in the U.S. or the U.S. will allow you to do one of these PCT applications that Tom mentioned a few moments ago, which will provide you with the opportunity to designate up to 180 other countries around the world. And then you have 30 months to go national back into, say, the U.S., for instance. So that's the first 1 year, that the time from provisional to the actual full application filing. Then the second 1 year period is what Tom was mentioning when he talked about international coverage. So somebody can decide that they're going to file a provisional in the U.S., wait up till a year, file a U.S. application, full application, and then they have up to a year to file internationally, during which time they might then decide to file that PCT application to make sure that they have coverage theoretically or potentially in all those other countries around the world. So just so there's confusion, there's two different one-year periods, provisional to full application, and then actual full application to international coverage.
So do I understand correctly that patent issue is not really important, that the company protected by actually filing?
Not if you want to sue somebody. The only way that you can exert your rights in a patent is if it grants somewhere, and only in the country by which you got that grant. So a pending U.S. application that gets published after 18 months, you can't sue anybody to exclude them from using that technology.
Yeah, so filing the patent application is basically, you're claiming you have this legal right, but it's not until the U.S. actually grants it that you can use that legal right. So it's kind of like, imagine, for instance, your driver's license, okay? Think of the learner's permit that you get before you get the driver's license. The learner's permit is kind of like the patent application. You're not actually a licensed driver when you have that learner's permit. You're just applying for it. And then once you get the actual driver's license, it's like getting the actual patent. At that point, you can actually use the patent to enforce it and exclude others from practicing your process or item or whatever it is you created.
So competitors can effectively use your invention before this happens, right?
Right, but there is potential for, think about it this way. If they're using the process before your patent issues, they're going to put themselves at risk because they're investing lots of money into something which infringes someone else's patent. And once that patent issues, at that point, they're kind of locked in unless they want to completely change what they're doing, which can be extremely expensive. So,
all right.
But yeah, that's something that can happen. Also, Tony is going to be giving a brief preview at the end of this presentation, and he'll be talking about what his presentation in 2 weeks is going to be about. So, all right, so we talked a brief little bit about patents and inventions. So what would you actually put in a patent application? Well, you basically want to describe what the invention is and what the problem is that it solves. You might want to put in how to make the invention, how to use it, why the invention is better than competing products. But you can kind of think of it almost like a research paper where you're describing this new product or this new technique, and you're explaining what it is what it is and what it solves. And so you're basically putting in words that describe that, written description of it, as well as diagrams to visually show it. And I'll show you some example patents in a few minutes and kind of draw this out. But before I do that, let me kind of talk about what the actual parts are in the patent application, and then I'll show you one or several. So basically, you have a title for the patent, like a new way of creating a quantum computer. You've got your technical field, is this in the field of quantum computing or the field of microwave ovens or whatever. You've got a background on the invention, which is optional, so it's not going to be in all patents. You've got a summary of the invention, typically a high-level couple paragraphs. A brief description of the drawings, again, usually a couple paragraphs just listing out what each of the drawings is. Then a detailed description, which is the longest part of the patent application. So this will be all the text of a research paper. It'll refer to the drawings. It'll describe exactly what's going on and whatever it is you created. Then we have what we call the claims. Now the claims are basically the property right you get from having a patent. So if you think about real property, real estate, in a real estate deed, it usually identifies the dimensions for the parcel of real property that you own. In a patent, those dimensions are the claims. And so the claims are meant to be based on the detailed description, but basically a subset of the detailed description describing exactly what it is you invented. And usually they're structured in what we'll call independent claim and dependent claim format, where an independent claim will be a description of something, and then the dependent claims narrow that description further by adding additional conditions. So an example might be of a claim might be, I claim that I created a laptop computer with a hard drive, a keyboard, and a visual screen. And then a dependent claim might say also including a disk drive, or also including serial ports. So the dependent claims further detail and define whatever it is that the independent claims described. And then there's typically an abstract, and then the drawings or figures that go along with the patent application. And again, I'm going to show you a couple examples of these in just a minute. We'll go through a couple of quantum computing patent applications and see what they look like. And then Tony in his presentation will talk in much greater detail about what's going on at the broad landscape level in terms of quantum computing patents. All right, so we talked earlier briefly about types of patent applications, and Tony mentioned the provisional application. So a provisional application is sort of like a temporary patent application, or you might think of it as something that you would do if you're not really sure whether you're ready to go to all the expense of a utility patent and you want to wait a little while before you file a utility patent. So for example, but basically what it is it's not a full patent application, and the patent office doesn't actually examine this at all. Instead, what you do is you send the provisional application in, and then sometime later, within 12 months, if you decide to go for a patent application, you file what we call the non-provisional utility patent. There are also design patents, and I'll talk about those in a minute. But basically, most patent applications are going to be utility patents. So that's what's going to be granted and turned into an actual patent if it survives the examination process. So why would you file a provisional application? Typically, you do that to maintain an early filing date. Maybe you're not ready to finish writing up the utility patent, or maybe you don't want to go to the full expense of the utility patent until you get additional funding from a VC. So you might do a temporary provisional application, in 6 months or 9 months or 12 months later, you file the utility patent.
What is the price? Sorry. What is
Go
the
ahead.
price, the cost for the provisional application? Is it free or less than the $20,000 for a full
All right.
utility?
Yeah. So okay. So let's talk a little bit about cost for a second. And obviously, if you go see a patent attorney, they can show you, charts of all the different fees that are involved. But at a ballpark, the fees for a small company for a utility patent at the patent office is going to be about $800 to file the patent application for non-provisional. And then there will be additional attorney fees, whatever your attorney would charge. And then during the examination process, you would, over that 3 to 5 year period, there would be additional expenses both to the patent office and to the patent attorneys. And then once the patent is granted, then there's additional maintenance fees you have to pay to the patent office to keep the patent in force. And so all of that can add up to be quite a lot over time, but it's not, $20,000 all at once. It's money over time. Now the provisional application is going to be significantly less than a non-provisional application. The government doesn't charge much in the way of fees. It's pretty minimal, a couple $100. But the attorney fees also for a provisional application tends to be significantly less because they don't have to do all the different parts of a patent application that a non-provisional requires. But you can't avoid doing the utility eventually because the provisional application is good for only 12 months. So it's really just a placeholder. But typically, if you were to go to the American IP Law Association, they actually have an economic report that lays out how much attorneys charge for different things. And I believe if you look at the most recent version of their economic report, they say the average in the U.S. for provisional application is probably around $4,000 in terms of attorney fees. But again, if you want the actual details, I'd recommend visiting that report, and I'll bring that up later when I'm showing some stuff on the web browser. Did that answer your questions about fees?
Yes.
Okay. Some other patent application types. Tony mentioned the PCT international application. There's also continuation and divisionals and continuation in parts. These bottom three, they're all variations of a utility application. And I'm not really going to dive into what they are, but basically it's just another way of doing a utility application. A design application is a little bit different from a utility application. So if we think about what the utility application is, it's describing an invention that does something, an invention that has some function or use. Like I'm creating a better toaster oven. I'm creating a better car, a better windshield wiper, better you name it. That's really what a utility application is. A design application is really about a better design of a product. So if we go back to like Steve Jobs on the iPhone, they had a number of design applications on how the iPhone looked, you know, where the buttons are, how the screen is set up. Those were design patents. So that's a separate type of patent. But it was because they had a very innovative design and they knew it was a valuable design and they didn't want other people to copy it. So those are different types of patent applications.
I have a question.
Yes.
So on the non-provisional application, I think you said that they're not generally reviewed by the USPTO.
No, the provisionals are not reviewed because they're temporary. The non-provisionals are the ones that are reviewed. These are the, because basically the provisional is just, it's really just a temporary time stop. You put that out there and then eventually it's going to be replaced by a non-provisional, or if you don't replace it, it'll just expire after 12 months and then it's dead. So because it's not really doing anything, it's just giving you a fact that you had created this invention at this particular time and date, they don't examine it because they assume that if you're willing to have it examined, you'll file a non-provisional and that's what they will examine.
Okay, so the non-provisional is really the main patent application then? Or
Yes.
is there something after that?
No, that's the main patent application, but it hasn't been granted yet until it goes through the examination process. And then once it's granted, I mean, granted means it's approved. So once it's approved by the government, then you can enforce the patent and prevent competitors from exercising whatever's described in your patent.
I have another question.
Sure.
If you happen to have a patent that's approved in the U.S., what happens if another country happen to use your process or whatever? Are you still protected from someone internationally or just within the U.S.?
So that's where this patent cooperation treaty international application comes from. If you only file the patent in the U.S., then you don't have patent protection outside the U.S. But if you go through this patent cooperation treaty international application approach, you can then file patents in other countries. And so you could file the same patent where you have a competitor overseas.
Okay.
And then if the competitor practices the patent overseas, then it would be up to that country's government and how their patent law works to deal with the issue.
Question?
Yeah.
Does filing provisional application protects your invention from, like, let's say your competitor files non-provisional a little later?
Yeah, under the first to file argument, if you file first, even though it's a provisional, you're protected against that competitor who files after you is non-provisional. So even though, for instance, let's say on day 1 you file a provisional, on day 30 your competitor files a non-provisional, you have up until 12 months later to file your non-provisional. So you can file your non-provisional like 6 months after the competitor's non-provisional, so long as your provisional application was before he filed his non-provisional or his provisional. Whoever came first wins.
I have a question on the actual content of the patent.
Yes.
So I don't know, you may go into this later, but if you do, please say so. So in terms of what constitutes a patent, I mean, do you have to actually have the invention created, or can it be an idea that scientifically you can prove will work, but you don't necessarily have the device actually made?
So it used to be a long time ago that they required that you actually have the device made and you actually had to send a device, which is why I showed you that picture of Abraham Lincoln's device, because he actually sent that in. Nowadays, however, they just require a written document that describes what the invention would do. So if you can create that written document that describes what the device will do, like for instance, device blueprints, okay? Think of it's that kind of, kind of a document. If you can create the document that describes the device, you don't actually have to submit the device. And in fact, they don't expect you to. I'll give an example of software. Now, software is a relatively complicated topic, and I'm not going to get into all the details on it. But nowadays, people file software patent applications all the time, and they don't include the software source code. They just include a description as to what the software will do.
So with software, I'm assuming that you would have to have some type of pseudocode, right, in terms of the algorithms?
You don't even need to have pseudocode, but it's a good idea to have pseudocode, because you will want to explain, what it's doing. So whether you give them the algorithm or you give them a written description of what the algorithm is, you're going to want to do something like that. Other questions? All right. If you want to learn more about patent law in general, there's a lot of information on YouTube. One of my favorite courses on patent law on YouTube is Penn Law School has a patent law and policy course on YouTube. It's a full semester length course. It's got all kinds of details in it. But there are many, many other YouTube videos on patent law. To learn more about copyright, I recommend copyright.gov. I'm going to show you a couple of websites for dealing with patents. I'll show you, Google has a patent search site. I'll also show you PublicPair, which is a public version of the patent application information retrieval site from the Patent Trademark Office. Patent attorneys actually have a private version of this one, which is very similar to PublicPair, except that they have it for, giving updates on patents that they're working on. So let me show you some of these. So I'm going to back out of here. Is my web browser coming up here?
No?
Yeah, I think. Yes or no?
No.
Yeah, still on the presentation.
All right.
Thanks.
Let me change what I'm sharing then. I see a couple chat things here. Okay. Oh, we got somebody here from Singapore?
Yep.
Let's get
Good morning.
All right, you should see my web browser now. This is the PublicPair site. It's a portal offered by the U.S. Patent and Trademark Office. You can come in here and you can search on any patent application or granted patent that you want to look up and find out information on. And so you can type in like the application number, patent number, and so on. I will come back to this in a minute. We'll actually look at one. But first, let's go over to Google Patents. All right, so I just did a very simple search in Google Patents, which is patentsgoogle.com. And I just threw in quantum computer and qubit. The reason why I threw qubit in there is because I was worried that if I didn't throw in something very specific to quantum computing, I would get all kinds of results. So I threw in quantum computer qubit, and one of the first, and basically I'll show you the results page first. So the results page I got here was, a bunch of patents and patent applications that mention qubit and quantum computer. And we'll notice actually that a lot of these are from D-Wave. It looks like the first 3, 4, 5, 6, 7, 8, 9. At least 8. The first 8 were all from D-Wave. Maybe all 10. The first 10 were from D-Wave. Okay, so anyways, let me go look at one of those. So I'm going to show you what this looks like in Google Patents, and then I'll show you what it looks like in the public affairs site. So just see what you can see. So the first thing that comes up when you click on it in Google Patents, you see the abstract for the patent. You see a little image, usually. They have the description. They have the claims over here on the right. And then they have a little bit of information about the patent over here on the right-hand side. They have, information like other applications and status and all that kind of stuff. They also have a button for download PDF, which allows you to get a copy of what the patent application looks like from the patent office. So typically what I do is, as opposed to reading it in Google, I usually just click on download PDF and I read the PDF. So I've already actually clicked on it, so I'm going to go over here to this PDF and I'll open it. So this is what it looks like when you get the PDF from the patent office. So typically what you've got is it'll say up at the top, United States patent. It will have the inventor name underneath that, and you can also see the inventor name right here. It'll have a patent number over there and also the date the patent issued. And so typically you'll have a title of the patent, like in this case, architecture for local programming of a quantum processor elements using latching qubits. In some cases, there'll be many inventors. This one just has one. Sometimes you'll see the assignee listed, sometimes not. In this case, it's assigned to D-Waves. So let me talk about what assignee means. Basically, in the U.S., the inventor is a person, an actual person. The inventor's not IBM or D-Wave or somebody else. And what happens is the inventors, typically as conditional employment, may assign intellectual property they create to their employer. And so in this particular case, Andrew Joseph Berkeley assigned his patent to D-Wave Systems. Other information you would find on this, you would find like the application number, what date it was filed originally. This one was filed in 2008. And then you would have, typically you're going to have a list of related applications and references that are cited. Now these references that are cited might have been cited by the patent office as part of the examination process, or they might have been supplied by the party that's seeking the patent saying, hey, these references might be related to my patent. And so they're listed on the patent application because they might be related, or they might be prior art references. Then you have an abstract, which is a paragraph describing the patent at a high level. In this case, they're talking about these latching qubits. Then they've got their first diagram here, but you'll notice it says there's 7 diagrams, so the others are at the back of this patent application. And here's some additional references that were cited as part of the prior art search. And so here's our diagrams. This diagram, a couple different diagrams, all trying to show what's going on with the signals in, the signals out, the clock, and so forth. Talking about, what exactly is going on with this latch qubit approach. So you see the different diagrams. And then we have what I'll call the detailed description, which is the actual description of the patent application. So this detailed description is where we've got all this written words describing what's actually going on. In this particular case, they provided a background. So they had a couple pages explaining what qubits are, what's going on in the technical field. They're talking about approaches to quantum computation. And they talk about superconducting qubits. And after they do the background, and they have a summary of their invention. And then after the summary of their invention, they have the list of the detailed description of the different figures, the brief description. And then they have the detailed description where they describe their particular invention on latching qubits in much greater detail. And this goes for a bunch of pages, actually. So I'm going to skip on down through there. And then down here at the bottom, they have their claims. So again, I mentioned before, the claims are kind of the property right you get. And so their first claim, first independent claim is a superconducting quantum processor with several component parts, and so they explain what their quantum processor is doing. And so they have, three little sentences here giving more details on what the processor is doing. Then they have dependent claims that narrow or add additional conditions onto those components, describing it in more detail. So that's a brief overview of a patent application as it's been filed and as it's been issued by the U.S. Patent and Trademark Office. Questions? Let me throw this open to the floor. How many people have seen patents before, besides Tony?
Yes. Hello. I'd like to ask a question if I could.
Go.
Since there's so much detail shown in the patent application itself, do companies ever purposefully hold back and not file a patent so that competitors don't see what they're working on?
Yes, but you might protect it as a trade secret then and not expose the details. But there's also a lot of legal doctrines where, if you don't reveal all the details, then your patent right might not be as strong as it would be as if you did reveal all the details. So the whole idea is the more details you reveal, the stronger your patent right should be in theory.
Okay, thank you.
Of course, that's in theory. So a lot of times companies will reveal some details and obtain patents on it, and other details they'll decide to keep a secret and they won't tell anyone. But then they don't have a patent protection on those secrets. So it's a trade-off.
So in the provisional patent, if you reveal only some parts of your, so those then?
So I heard a question asking, what about a provisional patent? So one thing I haven't talked about, because again, we're trying to avoid getting into too many details, is the provisional patent is actually not exposed to the world. Only the non-provisional patents are exposed to the world. So when you file a provisional patent, no one else is ever going to see that unless you decide to file a non-provisional patent, at which point, you're filing the non-provisional patent and you're exposing it. So if you file just a provisional patent and you decide after 12 months, hey, I decided I don't really want to file a patent, let's just keep it secret, then that's okay. No one will ever see the provisional. On the other hand, however, if after 12 months you do decide you want to file a non-provisional to claim priority to the provisional, at that point you do expose that provisional so people can see what was in it. So let's suppose you put like 2 inventions in a provisional application, and then later you decide to file a non-provisional on only one of the inventions. Well, the other invention was in that provisional and it will be exposed. It won't be a secret anymore. Other questions?
I had a question. So going back to the open source software piece that
Yes.
you're saying, what my understanding was that we cannot use all of the open source software for commercial use. Is there any way to find out that the open source software mentions that this can be used for commercial use or not?
Yeah. So what I was saying is that to really understand what's going on with open source software licenses, you should make sure you understand the open source software license you're using. So, for example, let's say, for instance, you want to use some software that was created with the Apache license. Well, the Apache license has certain conditions in it. So just understand what those conditions are, and so long as you comply with those conditions, you can use that software in a commercial offering. Lots of people sell products that are based on Apache licensed open source software. But you just need to know what those conditions are and you need to follow. And I was saying that certain open source software licenses are much more restrictive than Apache is. So for example, the GPL license is a much more restrictive license in terms of restricting what you can do with it. But again, that's something that you should have a discussion with, whoever is giving you advice in terms of, have that discussion with your legal advisor. It's just something to have in terms of a discussion.
What about MIT license compared to Apache?
The MIT license is very similar to the Apache license. So I would put them as among the most flexible in terms of allowing you to do things, and I would put the GPL among the most restricted. But there is, they all have their own individual details, and so all I was saying is, you have to look into that because that's, it's an issue of copyright law. Other questions? I'm going to go back to the slides here. Dive out of the slides here. So that was a brief look at the public pair and actually the Google's patent search. So on public pair, so let me go back. On public pair, what you could do is you could actually see all of the documents that have been filed to obtain that patent. I'm not going to dive through those documents, but you could see everything that the patent attorneys for the applicant had filed, as well as you can see what the government's response was, and you can see why the government issued that particular patent. So you can see all those details underneath public pair. So if you have other questions, feel free to get in touch with me offline. Here's my email address, first initial, last name, at harrisburgu.edu. As I mentioned earlier, I teach quantum computing for Harrisburg, and happy to talk about things related to quantum anytime you want. I'm also a patent attorney, so I'm happy to talk about patent stuff. And as I mentioned earlier, we've got 2 upcoming quantum law and policy lectures. We've got one from Tony on patenting in the quantum information technology realm. We've got one from Paul Steimers on current issues in U.S. quantum policy. As I mentioned earlier, Paul is a lobbyist on Capitol Hill. We're also in the process of signing up other people to talk about quantum law and policy. So feel free to reach out if you have any suggestions on who we should reach out to. Tony, would you like to give a brief intro to what you plan to cover in 2 weeks?
Yeah, if you can allow me to share my screen. I don't know if
Yep,
I can do that as a presenter.
Yes, you can.
Okay. So let me just go ahead then and bring up just one slide. Okay, hit the share button. There we go. So a few years ago, I put together a collection of reports looking at quantum computing. I started with looking more or less at the devices. Then I did a separate report on the applications, cryptography, communications, to some degree software. And then I combined them into a single report that I refer to as the Quantum Information Technology Report. You can download all of these for free on my website. I don't even ask for email addresses. But when we go through the landscape in some detail in a few weeks, this is one of the visualizations that I'll show, for instance. This is a really powerful visualization. This has got over 3,000 patent families having to do with quantum information technology overall, which is the devices as well as the applications. And you can see that it's broken out into different sections. This, for instance, down here are all the qubit generation type areas. So you have companies that are looking at using quantum dots, some using ion traps, some using topological qubits, and the majority of them using superconducting qubits. And it's actually then color-coded, in this case, by which patent families belong to D-Wave versus IBM versus Microsoft, the U.S. government, Northrop Grumman. And then actually the next page is the exact same map, but now I've got the Chinese companies on here, where Kasky, Szechuan Quantum, Chinese Academy of Sciences, Beijing University, and so on. And so 2 weeks from now, we're going to spend a lot of time talking about quantum patenting, and we're going to break it into the hardware and the applications, and we'll spend a great deal of time talking about some of the big companies and some of the trends over time that have taken place over this within this area since it really started to take off in the 2014 timeframe. That's when you see a huge jump. As a matter of fact, if I scroll up very quickly to the very first slide on here, you can see that right here at 2014, that's where everything went crazy. And that was part of the reason I picked this topic when I first looked at it a few years ago, was because you see things like this and they're nice and steady, and all of a sudden you get the hockey stick, and that's always something fascinating. It's usually, there's a very interesting story behind that. In any event, I will stop sharing, and thank you so much, Tom, for letting me briefly introduce what we're going to talk about in a few weeks.
Not a problem. I'm looking forward to it. Terrell, any comments?
Glad there's guys like you in the house to take care of all these details when they come up. Devil's in the details.
It is indeed.
Okay. I have a question.
Yes, go ahead.
Yeah, so question is about how realistic for a startup to protect from major companies patent-wise. Also, more specifically, I heard that if a company improves on your patent or on your idea, they don't really have to obey this patent anymore because they have like sort of an improved idea and they can just use it for free.
All right, so that's two separate questions. Why don't I take the first one first, and then I'll get back to the second one after the first one. All right, so the first question is let's say you're a small company, a startup, let's say two guys in a garage, and you're living the dream, you're having fun, and all of a sudden you get a letter in the mail from a big bad company saying, hey, I got 100,000 employees, and we've got patents on technology X, and we don't want you to play in our space. It can happen. You could get a letter like that. But generally speaking, the big guys are really focused on other big guys. They're less likely to notice, two guys in a garage. But let's suppose it does happen. So this kind of goes back to one of the earliest slides I showed tonight, which is why do startups and other entrepreneurs invest in intellectual property? The primary reason they do is not because they want to exclude others, it's they want to prevent others from excluding them. So if IBM sends you, or some other big company sends you a letter saying, hey, we want to exclude you because we have patents, your response is to say, hey, well, I've got patents too. And then what you do is you negotiate with them, and at the end of the day, not all, but a lot of cross-licensing agreements end up with both companies staying in business. So that's my number one recommended defense strategy is if you're worried about being excluded by others, is have your own IP rights, and then you can cross-license and everybody stays in the game. So let's talk about the second question you asked, which is what if another company comes along and makes an improvement? So let's say, for instance, you came up with this great idea. You filed a patent on it, and someone else comes up and decides, hey, wait a second, I can improve it by changing this one little thing. All right? So your original patent prevents the other party from exercising your original invention. If, in order to exercise their improvement, they have to exercise your original invention, then they are actually exercising your original invention. However, if their improvement removes something that was in your original invention, then they're no longer exercising your original invention. And there's a number of complicated legal doctrines that deal with this issue. But the end result of it is usually if both parties have patents, the original party has a patent on the original process and the other party has a patent on the improvement, in many cases they end up cross-licensing the patents, as I mentioned earlier. And so that's something that can happen.
Thank you.
Other questions?
I'd like to ask a sort of a question with that in mind. If a startup wants to use a patent from somebody else in order to start a business, how deep into the patent field do you need to go in order to create based on that patent? For example, do you need to also license the prior art and other references and everything around that patent, or can you just license that patent?
So that's a really complicated issue. In general, if you're a startup, a lot of startups are trying to create their own technology. So they're not starting off from the process of saying, hey, I want to license someone else's technology. But if you've come to the conclusion you want to license someone else's technology as opposed to creating your own, then, you want to think about, okay, yeah, how much is it going to cost to license it? And is there other stuff I'm going to need in addition to this? And so that is a complicated question. The other thing to keep in mind is that licenses tend not to be very cheap. There are some cheap licenses out there, but there's also some really expensive ones. So that's something to think about as well, too. Other questions? All right. Well, I'd like to thank everyone for attending tonight. Terrell, any last minute comments about upcoming speakers?
Just watch Quantum Palooza. It tells you everything I want to say. We have, those of you who are interested, in fact, on Wednesday night, U.S. East Coast time, we're having an experimental event that involves just a hangout and a party for quantum people. So it'll be using one of those other technologies out there that's kind of cool and useful for socializing and things like that. So I'm a little behind schedule on it in that what I'd like to do is invite prior speakers that we've had over the past few months to attend the event. So if you want to hobnob with one of your favorite speakers from the Philadelphia or Harrisburg meetup, hopefully he or she might be in attendance. I'm a little behind on their invites for that, but there are a few that I know should be there on Wednesday night. So it's a good chance to take some time and hang out with your other quantum climbers as well. Many of you recognize each other's names. I see many of you over and over again. So this will be a time, it's just an hour long, 6 p.m. on Wednesday night. So sign up at the meetup. There may be some special sign up arrangements. I'm not sure. I'll be figuring that out over the next 24 hours. But if you got nothing to do on 6 p.m. Wednesday night, sign up and hopefully we'll see you there. Otherwise, just check Quantum Palooza for, I don't know, I think there's like 60 some odd events on the schedule. So not all ours, of course. Okay, any comments, anybody?
Thanks everyone for attending tonight's presentation.
Yeah, we hope to see you all again for this series, among other events as well. Thank you, Tom, and also Tony for joining us as well and adding a few comments as well. Tom, thanks, and we'll end here.
I just had a question. What was Tony's website, please?
I'm sorry?
What was Tony's website? I missed that.
Oh, yeah. Tony, do you have, can you pop the URL in the chat?
Yep, there you go. It's patinformatics.com. Right there from the homepage, there's a link to the quantum computing page. And like I said, all four reports, there's one on QIT, one on application, and then two of them on the devices. One, it just has the highlights, and the other one's a 60 slide deck. So there's one big deck and a couple of smaller ones.
Okay to put that URL on your event page?
Oh, of course.
Cool. Okay.
Will do. And from day one, those reports were made available for free. It was just an idea to get it out there and get people talking about it, and it's worked out really well because even Tom found it just by poking around, and those reports have been written up in the Wall Street Journal, Washington Post, CNN, Wired, Bloomberg, and MIT Technology Review. So there's a high level of interest in what China is doing, which I didn't mention as well. So
Yeah, I'm particularly interested in China. All right. Well, thank you, Tony.
yep,
I'll put that on the event site then. So, okay. That's it for tonight then, folks. Thank you very much for attending. We'll see you again next time. Tom, thank you again. Cheers.